Triadic trusts, the story of three things: a person, a property, and a document. Let's imagine a question that most people have never really asked. What is a trust? Not the emotional kind. Legal trust. The kind of trust that holds property, governs who gets what, and survives long after its creator is gone. The kind that can give rights to children, protect assets from creditors, or manage an inheritance over generations. You might think of a trust as something complicated, but at its core, it's built out of three ordinary elements: a person, a piece of property, and a legal document. One human being decides to transfer something they own into a structured relationship governed by law. That decision creates a new kind of legal object, the trust. But for a trust to work, for it to become real in the eyes of the legal system, these three elements don't just have to exist. They have to interact, and not randomly. They have to form very particular patterns of dependence, causality, and mutual reinforcement. This is where we turn to the logic of triads. Each triad we'll examine shows how these three basic things, an individual, a property, and a legal document, combine to form a legal structure that gives others enforceable rights. And we begin with the first triad, the most basic one: coexistence. A trust cannot begin with just a good idea. It needs three things to coexist at the same time, each pointing to and depending on the others. First, there must be a person with legal capacity, someone alive and legally competent, called the settler, who is capable of making decisions about property. Second, there must be a specific item or class of property. This could be money, land, shares, or anything else capable of being legally owned and transferred. And third, there must be a document, a trust instrument, that expresses the settler's intention to create a trust and sets out its terms. These three, person, property, and paper, must all be present at once. You cannot form a trust by writing a document that refers to property you don't yet own. You cannot form a trust without specifying what is being put into it. And you cannot form a trust by naming property in casual conversation with no written terms. The law doesn't guess. It doesn't infer. It recognizes coexistence as a strict condition. But it's important to understand what coexistence accomplishes and, what it doesn't. These three elements together form the minimum skeleton of a trust. But so far, no rights have been created. No one has the power to enforce anything yet. What coexistence gives us is structure, a base form the law can begin to work with. Like a blueprint for a building, it lays out the possibility, but nothing is yet built. Once the basic elements exist together, something must happen to bring them into legal effect. This second triad is about reinforcement, how actions and recognitions build on each other to convert structure into enforceable legal standing. This process begins with the settler's intent, not just any intent, a specific mental act to create a fiduciary structure. The settler must intend not to retain full ownership or control of the property, but to place it into a structure that obligates another person, the trustee, to manage it for someone else's benefit. That internal act is then followed by an external one, a formal transfer of property. The asset identified earlier must be legally conveyed into the trust. That could mean titling a bank account in the name of the trust, deeding a house to the trustee, or executing a legal assignment. When this transfer is made according to the intent expressed in the document, the legal system now has something to recognize. Courts, registrars, and administrative bodies acknowledge that the trust exists, not just as a theory, but as an active structure that can be upheld, enforced, or reviewed. The trust has moved from possibility to reality. Beneficiaries now begin to gain legal visibility. If someone were to challenge their rights, a court could now entertain the question. The trust has enough reinforcement, enough mutual support between intent, action, and recognition, that it can stand as a legally operative form. Without all three, intent, transfer, and recognition, something crucial is missing. An intent without a transfer is just a wish. A transfer without recognition might have legal consequences, but it doesn't form a trust. A document without any real-world action does nothing. Only when these elements reinforce each other does the trust gain a foothold in law. Now that the trust exists and is legally recognized, we ask the deeper question: Where do rights come from? The answer lies in the third triad, causality. A trust is not just a structure. It is a source of enforceable obligations and rights, and those don't arise all at once. They emerge through a sequence of events with real legal consequences. First, the settlor makes a formal declaration of trust. This is more than intent. It is a specific statement that a named trustee will hold certain property, not for themselves, but for a named beneficiary. This declaration is the first cause. It lays the foundation for dividing legal ownership from beneficial interest. Second, the property is actually transferred into that arrangement. The trustee is now given fiduciary title. This means they hold legal ownership, but not for their own benefit. Their role is to manage, administer, or distribute the property according to the terms of the trust. That shift, where someone holds ownership but can't use it for themselves, is a fundamental transformation. It doesn't happen without the declaration, and it can't happen without the transfer. Third, and most importantly, the beneficiary gains rights. These are not vague expectations or moral claims. They are enforceable legal entitlements. If the trustee fails to act as required, the beneficiary can go to court. A judge can compel performance, order an accounting, or even replace the trustee. These rights are not given directly by the settlor. They are caused by the trust structure itself, by the interplay between declaration, title assignment, and legal recognition. This triad is the engine that turns structure into power. At this point, the trust is real. It is recognized. It generates rights. But how does it operate? This is where we encounter a more subtle, sophisticated triad, nonlinearity. In most legal relationships, the person who owns something can control it, use it, give it away. But in a trust, the original owner, now the settlor, has stepped back. They have executed the trust, signed the document, and handed over the property. They have no direct control anymore. Now, the property is held by a trustee, but the trustee doesn't simply act as a new owner. They are bound by the dispositive terms of the trust, the specific instructions laid out in the trust document about how the property is to be used, who benefits, when, and under what conditions. These terms define the trustee's powers, the beneficiary's rights, and the structure of administration. And here's the key point. These terms operate independently of the settlor's ongoing wishes. The settlor may be dead, they may be silent. It doesn't matter. Once the trust is properly formed, the structure runs non-linearly. Its rules are embedded in the document, and the trustee's legal control is bounded by those rules. This separation of intent, title, and benefit allows the trust to function as a kind of legal machine. The settlor creates it, but once it's created, it operates according to its own logic. That's the meaning of non-linearity. The trust doesn't flow from settlor to beneficiary in a straight line. It flows through the terms, through the trustee's role, and through the obligations encoded in the structure. The trust has become an autonomous legal entity, not a person, not a contract, but a system of rights and duties that moves forward on its own. After a trust is created, we need to understand how it becomes legally binding, not just as a relationship, but as a formalized structure that obligates performance. This triad marks the point at which the trustee's duties become fully real, and the beneficiary's rights become enforceable, not just in theory, but in practice. The first element is the grant of legal title. This means the property identified in the trust instrument has actually been vested in the trustee. The trustee now legally owns the asset, but critically, not for their own use. That transfer is what enables the trustee's role to exist. The second element is the establishment of fiduciary duty. These are not vague moral expectations. They are legal obligations to act loyally, prudently, impartially, and in the interest of the beneficiary. The moment the trustee receives title, they are no longer just a legal holder, they are a fiduciary. They are constrained by duties defined in law and sharpened by the terms of the trust. And the third element is the formation of the trust relationship itself. Settlor, trustee, and beneficiary now stand in a triangular legal configuration. This structure is not optional or interpretive, it is constitutive. Once the grant is made and the duty arises, the relationship exists in full. That's what we mean by inclusivity. The trust structure now necessarily includes the beneficiary's rights. They are not an afterthought. They are a logical and legal consequence of the way the trust has been assembled. From here on out, no one can say the beneficiary's claims are optional or subject to the whims of the trustee. They are embedded in the system. Now that we know rights exist, the next question is, to what exactly do they apply? What property is actually governed by the trust? What rules control it? Who gets to interpret them? This is where the triad of conjoining matters. It ties together the settler's capacity and action, the specific assets, and the operative language of the trust to determine what exactly the trust controls and what the beneficiaries have rights to. First, the settler must have had legal capacity at the time they created and signed the trust. That's not a mere formality. Capacity gives validity to every term in the document. If the settler lacked capacity due to age, illness, or coercion, the document may fail entirely. So the person must be competent, and the execution must reflect their true legal will. Second, the property must be clearly identified. In most trusts, this takes the form of a schedule of assets attached to the trust instrument. These might include real estate, financial accounts, or even intellectual property. If a valuable asset is not listed or properly assigned, then it's not part of the trust. That matters deeply when beneficiaries assert rights. They only apply to assets that were actually included. Third, the language of the trust document must match and govern those assets. It must clearly explain how the trustee is to manage the assets, how distributions are to occur, and under what conditions. Language without assets is meaningless. Assets without language are ungoverned. Capacity without either is powerless. So this triad, capacity, identified property, and governing terms, is about specifying the boundaries of the trust. It draws a line around what the trust controls, and therefore what the law can enforce. Without that precision, there are no effective rights, only confusion. Every legal structure must eventually be proven. Someone must be able to stand before a court, a bank, or a third party and say, this is real, this was properly created, this is valid. The harmonic triad captures this moment. It ensures that the essential components of the trust not only exist, but correspond in a way that can be verified. So the first component is the identity of the settler. It must be clear that the person named in the trust is a real legal person, traceable through signature, documentation, or record. Ambiguity in the settler's identity can, fatally undermine the trust, particularly if fraud or coercion is alleged. The second component is the specificity of the property. The trust must be able to point to property with clear title. If there's any doubt about whether the settler owned the property or whether it was ever conveyed into the trust, the entire structure is cast into doubt. The third component is the signature on the trust instrument. This isn't just formality, it is the evidentiary keystone. The law presumes a document signed by a competent party is binding. That signature is what unites the person, the property, and the terms into a single legal instrument. What makes this a harmonic triad is that each element supports and confirms the others. A real person owning a real asset, signing a real document. Each pair implies the presence of the third. Without that harmony, without that alignment, any claim to enforceable rights becomes vulnerable. This triad ensures the trust is not just valid in theory, but provable in fact. Now that we know a trust exists, that it applies to specific assets, and that its legitimacy can be verified, we come to a more philosophical but equally legal question. What is the trust for? Every trust is created with some designated purpose, perhaps to support a child, manage a charitable fund, or ensure continuity of family wealth. That purpose must be expressed by the settler and realized through the operation of the trust. The first component is the settler's articulated purpose. This may be stated explicitly in the preamble of the trust or, inferred from its dispositive terms. A trust without purpose is suspect. Law does not enforce abstract ownership divorced from intent. Second is the corpus, the body of property actually held by the trust. This is the fuel the trust runs on. Without a corpus, there's just no resource from which any benefit can flow. And the nature of the corpus, whether it's cash, land, securities, often determines how the purpose is to be fulfilled. Third are the documented terms of use. These are the instructions, how the trustee is to administer the corpus to fulfill the settler's purpose. These terms may provide for distribution, investment, restraint, or timing, and they must correspond to the corpus and the intent. They can't contradict each other. What makes this a convergent triad is that each part implies the others. If there is property and detailed instructions but no evident purpose, then the trust's rationale is incomplete. If there is a purpose and instructions but no property, the trust is functionally inert. If there is a purpose and property but no terms, the trustee has no legal guidance. Rights, duties, and enforceability emerge only where all three converge. At this stage in the life of a trust, the basic relationships have all been built. But the system still needs to balance its distributed powers and entitlements. Who holds title? Who receives benefit? Who ensures everything functions lawfully? This triad answers that by laying out three core roles that together define the trust's ongoing legal balance. First, there is legal ownership, held by the trustee. This isn't like ordinary ownership. The trustee has title but not freedom. They must hold the property under the constraints of fiduciary law and the trust's terms. Legal ownership gives them authority to act, but not to benefit. Second, there is the equitable interest, held by the beneficiary. This is the legal recognition of the right to receive benefit from the trust. It may be income from investments, the right to reside in a home, or eventual ownership of the corpus. Equitable interests are protected not by direct control of the asset, but by the ability to compel performance. And third, there is the legal power of enforcement, typically held by courts, administrative bodies, or a designated protector. This third element is essential. Without enforcement, neither legal title nor equitable interest can be secured. The system would break down into either overreach by the trustee or uncertainty for the beneficiary. What defines this as a combination triad is that each of these roles is incomplete without the others. Legal title without enforcement becomes unchecked discretion. Equitable interest without ownership is impotent. Enforcement without rights or duties is purposeless. The combination of all three, title, benefit, enforcement, is what gives the trust its internal legal equilibrium. Rights are not merely stated, they are protected because the structure is distributed and capable of correction. Now that we see how power is distributed, we turn to how parties are connected within the trust. A trust is not just a system of entitlements, it is a directed structure of benefit. The law must know from whom, for whom, through whom. This is the triad of association. The first element is the grantor's designation of a trustee. This is not just about naming a manager. It is about creating the vector through which the settler's intent is transmitted. The trustee is not simply a placeholder. They are the operating core of the trust, the person who must act, interpret, and deliver. The second element is the assignment of the corpus to that trustee. A trustee without control over assets is powerless. It is only when property is placed in their hands, legally and functionally, that their duties begin to take shape. Possession is not mere formality here. It is the bridge between authority and responsibility. The third element is the named beneficiary within the instrument. The trust's direction becomes meaningful only when it terminates in a recipient. Without a beneficiary, there is no purpose. Without purpose, there is no obligation. The named beneficiary transforms the structure from ownership into stewardship. This triad is one of relational directionality. The settler empowers the trustee. The trustee manages the property. The beneficiary receives the benefit. If any link is missing, no trustee, no corpus, no beneficiary, the chain fails. But when all three are present, we see a closed loop of legal direction flowing from intent to administration to enjoyment. Now we arrive at the final form, the triad of integration, where the trust becomes a fully self-operating legal system. It now functions without reliance on any one actor's continuing involvement. The system itself generates, transmits, and delivers rights according to its internal logic. The first component is the settler's delivery of intent and property. This is no longer theoretical. It is the initial encoding of purpose into action. By transferring property and expressing the plan, the settler breathes life into the trust. The second component is the trustee's custody and administration. The trustee receives not just the asset, but a role, one bounded by duty, procedure, and discretion. They act under law, not personal preference. They are the executor of a system, not its author. The third component is the flow of benefit, governed by the trust's terms. The beneficiary receives from the trust not randomly, not through favor, but through law. The conditions of receipt, timing, amount, form, are all governed by what the settler designed and what the trustee applies. This is the moment when the trust ceases to be a project of the settler and becomes an autonomous legal engine. The system is now capable of continuing even if the settler is gone, the trustee is replaced, and the beneficiary changes. It is not personal anymore, it is institutional. That's the meaning of integration. Intent, duty, and benefit are locked together in a system whose rules are operative, whose roles are interlocked, and whose rights are enforceable across time. What emerges from this triadic account is not just a legal checklist, but a coherent architecture. A trust is not a single act or form. It is a multi-stage structure, where each triad introduces a layer of legal, relational, and operational complexity. Each step, from coexistence to integration, adds precision, obligation, and enforceability to the one before. And each step depends on the integrity of the whole. To understand a trust is to understand that no single component is sufficient. Legal intent without property achieves nothing. Property without fiduciary duty creates risk but no governance. A trustee without a beneficiary is merely a placeholder. Dispositive terms without purpose or enforceability are inert, even where rights appear to exist. If the evidentiary, administrative, or directional structure collapses, those rights dissolve into ambiguity. In short, a trust becomes fully operative only through the integration of every structural element described above. This is not redundancy, it is legal interdependence. Remove one piece and the others begin to fail. Omit a triadic function, capacity, transfer, declaration, assignment, specification, enforcement, and the structure disintegrates not merely in form, but in substance. A trust is therefore not a document, a transaction, or a property arrangement. It is a system of intentional delegation, fiduciary control, and enforceable benefit. Only by carefully constructing and maintaining every link in the chain of triads can that system do what it was designed to do: survive the settler, bind the trustee, and protect the beneficiary.